In today's topic, we explore equality of arms in family court procedure, disclosure, and the reality of financial remedy proceedings. This is a detailed, legally grounded breakdown of equality of arms in family courts, including the financial remedy process, Form E disclosure, FDR hearings, judicial impartiality, and the impact of procedural imbalance. We examine where the system is exploited, how methods described as creative layering are used to gain unfair advantage, and why victims of domestic abuse who are in a state of shutdown cannot effectively advocate for themselves. Covering Article 6 of the Human Rights Act 1998, FPR Part 3A, and the Marital Causes Act 1973. So welcome. I'm your host, Samantha. This is Silent Screams, Loud Strength. We are unmasking justice. This is the series where we speak about those things. You are told that you have the right for a fair hearing when you appear in court, but no one examines what that actually means once the process begins. In the last episode, we established a principle that fairness in law is not about appearance, it is about function. Today we go a little bit deeper. We are going to break down what equality of arms actually means, how financial remedy proceedings work in practice, where the gaps in the system exist, how these gaps are exploited, what creative layering really is, and why it is not creative at all, and why victims of domestic abuse, when they are in a state of shutdown, cannot actively advocate for themselves. Therefore, they are not participating, because without understanding the process, you cannot understand where it fails and where it fails you. So, what is equality of arms? Equality of arms is a legal requirement under Article 6 of the Human Rights Act 1998. It means each party must have reasonable opportunity to present their case without substantial disadvantage compared to the other party. Now here is the key. Equality of arms is not about equality of outcome. It is about the ability to engage, the ability to respond, the ability to challenge, the ability to sustain the process. If one party can instruct continuously, fund prolonged proceedings, generate extensive documentation, and the other cannot, then the court must actively manage that imbalance. Because without intervention, process itself becomes the advantage. So what actually happens in divorce? Financial proceedings. Let's strip this back a little and explain the process clearly. So stage 1, divorce. Application. One party files for divorce, no fault system, conditional order. Okay, formally decree nisi. Final order, formally decree absolute. This ends the marriage, but it does not resolve the finances within the marriage. So stage 2 is the financial remedy proceedings. This is where most of the complexities and risks sits. So step 1 is the Form A application, which triggers financial proceedings. Then step 2 is Form E, disclosure. Each party must provide assets, liabilities, income, business interests, pensions, and all these are supposed to be a full and frank disclosure. This is critical. It's a very critical issue. So, Form E is largely self-reported. There is no automatic real-time verification within HMRC, Companies House, banking systems. This is a big structural gap. This is where things start to sort of fall into the gaps I spoke about. So step 3 is the first appointment for FDR. The court identifies issues, orders further disclosures, sets out directions. Step 4 is the financial dispute resolution, the FDR. This is a without prejudice hearing. So the judge indicates a likely outcome, encourages settlement at this stage. If settlement fails, then step 5 is final hearing. This is where the judge determines outcome based on the disclosure, the evidence, the submissions of Section 25 factors under the Marital Causes Act 1973. So, what happens if the disclosure failure and Form E limitations are present? The entire system depends on the truth of the disclosure, which is self-reporting. But where information is incomplete, narratives are inconsistent, documentation is complex or delayed, verification becomes difficult because the system relies on challenge by the opposing party, forensic scrutiny, judicial interpretation. So if one party lacks resources, expertise, capacity, then the disclosure may not be fully tested. And once that happens, so this factual foundation of the case, this is the factual foundation of the case which becomes unstable in the whole FDR process. So exploitation of the gaps, creative layering. This is now where we address the harmful reality within the process. The gaps in the system are deliberately exploited by those who understand how the rules work. What is often described as creative layering is presented as a sophisticated or a complex method of managing finances or assets. But let us be clear, this is not creativity. It is not innovation. It is a form of exploitation. It refers to the practice of structuring assets, finances, or legal arrangements in multiple layers using complex structures, transfers between entities or arrangements designed to make it hard to trace ownership, value, or origin of funds. This is done not for legitimate business or personal reasons, but it is done to hide assets, avoid proper disclosure, and gain unfair advantage. It is a way of making what is rightfully another person's property difficult or impossible to find, to access, or to claim. So these methods are used to create uncertainty, to delay the process, and to ensure that the person with the knowledge and resources can control the outcome. And because the system relies on disclosure and verification that is not automatic, these structures can be implemented and hidden for long periods, allowing people to strip assets or manipulate financial positions without immediate detection. So, victims and vulnerable victims who are in a vulnerable state of shutdown response, this is where the system fails those who need it the most. Victims of domestic abuse in a state of shutdown cannot participate. So when someone is experiencing domestic abuse or coercive control, financial control, they enter into a state of psychological shutdown. This is a natural survival response. It is not a choice, and it is not a sign of weakness. Shutdown is a state where the mind and the body become overwhelmed by fear, stress, and trauma. In this state, a person loses the ability to process information, to make decisions, to think clearly, or to take action. They cannot advocate for themselves. They cannot ask questions. They cannot challenge what is being said or done. They cannot gather evidence, understand the complex documents, or keep up with the pace of the legal proceedings. For someone in this state, the gaps in the system become even wider, where another person might be able to follow the process in real time and understand the rules and challenge unfair practices. A person in a shutdown is simply unable to do so. They cannot identify when disclosure is incomplete or false. They cannot see when assets are being hidden or stripped away or transferred. They cannot keep up with the legal demands or procedural steps. This means that while those who exploit the system use complex methods to gain advantage, victims are left unable to participate effectively. The balance, the equality of arms requires is impossible to achieve when one party is operating without full capacity. The knowledge and the other is functioning at reduced level, unable to engage or respond. This is not just a procedural issue, it is a human issue, and this is why so many victims find themselves unable to protect their rights, their assets, their security, even when the law is supposed to be on their side. This is when the law and the system is weaponized through the gaps. So the judicial structure and impartiality. Now, we turn to a judicial structure. In England and Wales, many family cases are heard by recorders, part-time judges, who may also practice as barristers. This is a recognized structure within the system. However, it raises a lot of perception issues. The need to ensure that impartiality is maintained, impartiality is visible, confidence in the system is preserved. But because justice must not only be done, it must be seen to be done. This is not an allegation. This is a structural reality that requires transparency, clarity, trust. So, where the siloed systems and structural limitations happen within the judiciary. Now, let's step back a little bit. The system is fragmented. Information sits across HMRC, Land Registry, Companies House, courts, banks. These systems do not operate as one. They operate in silos. This creates a fundamental limitation during proceedings and disclosure. The court cannot have automatic unfiltered visibility of these documents for verification. So the burden shifts: disclosure, challenge, interpretation, and now where the process is uneven, the outcome may reflect access and capacity, not just merit. There is disparity. There is no consistency. There is no verification because it's self-reporting. So let's be clear. Equality of arms, practical fairness cannot theoretically balance. Financial remedy law requires verified disclosure, not assumed truths. Judicial impartiality requires active case management, not passive neutrality. And the system requires that closing these gaps, addressing vulnerability, ensuring fairness for all happens in real time. When these elements are aligned, justice functions in the way it should, as balanced scales. Where there is not, the process becomes power and exploitation becomes possible, and many use this process for their own advantage. Therefore, the law must, for everyone, not just those who know how to play the game, but for those who need protection. The court, the culture in the courts must catch up to the law. So, in the next episode, we address disclosure wars, why financial truths fail within the courts. See you in the next episode.